Syllabus. Trump, President of the United States, et al. V. Casa, Incorporated, et al. On application for partial stay number 24A884. Argued May 15, 2025, decided June 27, 2025. Plaintiffs, respondents here, individuals, organizations, and states, filed separate suits to enjoin the implementation and enforcement of President Trump's Executive Order number 14160. C. Protecting the meaning and value of American citizenship, 90 Fed. Reg. 8449. The Executive Order identifies circumstances in which a person born in the United States is not subject to the jurisdiction thereof, and is thus not recognized as an American citizen. The plaintiffs allege that the Executive Order violates the 14th Amendment Citizenship Clause, Section 1, and Section 201 of the Nationality Act of 1940. In each case, the district court entered a universal injunction, an injunction barring executive officials from applying the executive order to anyone, not just the plaintiffs. And in each case, the Court of Appeals denied the government's request to stay the sweeping relief. The government argues that the district courts lacked equitable authority to impose universal relief and has filed 3 nearly identical emergency applications seeking partial stays to limit the preliminary injunctions to the plaintiffs in each case. The applications do not raise, and thus the court does not address, the question whether the executive order violates the Citizenship Clause or Nationality Act. Instead, the issue the court decides is whether, under the Judiciary Act of 1789, federal courts have equitable authority to issue universal injunctions. Held, universal injunctions likely exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. A. The issue raised by these applications, whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order, plainly warrants this court's review. On multiple occasions, and across administrations, the Solicitor General has asked the court to consider the propriety of this expansive remedy. As the number of universal injunctions has increased over the years, so too has the importance of the issue. B. The government is likely to succeed on the merits of its claim that the district courts lacked authority to issue universal injunctions. C. Enken v. Holder, holding that for a stay application to be granted, the applicant must make a strong showing of likelihood of success on the merits. The issuance of a universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over all suits in equity, and still today, this statute is what authorizes the federal courts to issue equitable remedies. This court has held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Grupo Mexicano de Desarrollo, S.A. v. Alliance Bond Fund, Inc. Universal injunctions are not sufficiently analogous to any relief available in the Court of Equity in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice, where it would not be secured by the ordinary and existing processes of law. This judicial prerogative of the king, thus, extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown instituted the practice of delegating the cases that came before the judicial prerogative to the Chancellor for his sole decision. The general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no exception. There were sometimes suits to restrain the actions of particular officers against particular plaintiffs. Of importance here, suits in equity were brought by and against individual parties, and the Chancellor's remedies were generally party-specific. See Iveson v. Harris, 7. You cannot have an injunction except against a party to the suit. In sum, under long-standing equity practice in England, there was no remedy remotely like a national injunction. Nor did founding-era courts of equity in the United States chart a different course. If anything, the approach traditionally taken by federal courts cuts against the existence of such a sweeping remedy. Consider Scott v. Donald, where the plaintiff successfully challenged the constitutionality of a law on which state officials had relied to confiscate alcohol that the plaintiff kept for personal use. Although the plaintiff sought an injunction barring enforcement of the law against both himself and anyone whose rights were infringed and threatened by it, the court permitted only relief benefiting the named plaintiff. In the ensuing decades, the court consistently rebuffed requests for relief that extended beyond the parties. See, e.g., Perkins v. Lukens, Steele v. Frothingham v. Mellon, decided with Massachusetts v. Mellon. The court's early refusals to grant relief to non-parties are consistent with the party-specific principles that permeate the court's understanding of equity. Neither declaratory nor injunctive relief, the court has said, can directly interfere with enforcement of contested statutes or ordinances, except with respect to the particular federal plaintiffs. Doran v. Salem Inc. In fact, universal injunctions were conspicuously non-existent for most of the nation's history. Their absence from 18th and 19th century equity practice settles the question of judicial authority. While equity is flexible, Grupo v. Mexicano, the court's precedent emphasizes that its flexibility is confined within the broad boundaries of traditional equitable relief, and broad boundaries of traditional equitable relief. Because the universal injunction lacks a historical pedigree, it falls outside the bounds of a federal court's equitable authority under the Judiciary Act. C. Respondents' counterarguments are unavailing. 1. In an effort to satisfy Grupo Mexicano's historical test, respondents claim that universal injunctions are the modern equivalent of the decree resulting from a bill of peace, a form of group litigation in the Court of Chancery. Respondents contend that the existence of this historic equitable device means that federal courts have the equitable authority to issue universal injunctions under the Judiciary Act. The analogy, however, does not work. True, bills of peace allowed courts of equity to adjudicate the rights of members of dispersed groups without formally joining them to a lawsuit through the usual procedures. Arizona v. Biden. Unlike universal injunctions, however, which reach anyone affected by executive or legislative action, bills of peace involved a group that was small and cohesive. And unlike universal injunctions, which bind only the parties to the suit, decrees resulting from a bill of peace would bind all members of the group, whether they were present in the action or not. The bill of peace lives in modern form, but not as the universal injunction. It is instead analogous to the modern class action, which, in federal court, is governed by Rule 23 of the Federal Rules of Civil Procedure. Rule 23 requires numerosity, such that joinder is impracticable, common questions of law or fact, typicality, and representative parties who adequately protect the interests of the class. The requirements for a bill of peace were virtually identical. By forging a shortcut to relief that benefits parties and non-parties alike, universal injunctions impermissibly circumvent Rule 23's procedural protections. 2. Respondents contend that universal injunctions, or at least these universal injunctions, are simply an application of the principle that a court of equity may fashion a remedy that awards complete relief. But complete relief is not synonymous with universal relief. It is a narrower concept, long embraced in the equitable tradition, that allows courts to administer complete relief between the parties. Kinney Coastal Oil Co. v. Kiefer. To be sure, party-specific injunctions sometimes advantage non-parties, Trump v. Hawaii, but they do so only incidentally. Here, prohibiting enforcement of the executive order against the child of an individual pregnant plaintiff will give that plaintiff complete relief. Her child will not be denied citizenship. And extending the injunction to cover everyone similarly situated would not render her relief any more complete. So, the individual and associational respondents are wrong to characterize the universal injunction as simply an application of the complete relief principle. The inquiry is more complicated for the state respondents because the relevant injunction does not purport to directly benefit non-parties. Instead, the District Court for the District of Massachusetts decided that a universal injunction was necessary to provide the states themselves complete relief. As the states see it, their harms, financial injuries, and the administrative burdens flowing from citizen-dependent benefits programs cannot be remedied without a blanket ban on the enforcement of the executive order. Children often move across state lines or are born outside their parents' state of residence. Given the cross-border flow, the states say, a patchwork injunction would prove unworkable for the provision of certain federally funded benefits. The government retorts that even if the injunction is designed to benefit only the states, it is more burdensome than necessary to redress their asserted harms, see Califano v. Yamasaki, and that narrower relief is appropriate. The court declines to take up these arguments in the first instance. The lower courts should determine whether a narrower injunction is appropriate, so we leave it to them to consider these and any related arguments. 3. Respondents defend universal injunctions as a matter of policy. The government advances policy arguments running the other way. As with most questions of law, the policy pros and cons are beside the point. Under the court's well-established precedent, see Grupo Mexicano, because universal injunctions lack a founding-era forebear, federal courts lack authority to issue them. D. To obtain interim relief, the government must show that it is likely to suffer irreparable harm absent a stay. Enken. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against non-parties. INSV Legalization Assistance Project of Los Angeles County Federation of Labor. See also Maryland v. King. Anytime a state is enjoined by a court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. The court's practice also demonstrates that an applicant need not show it will prevail on the underlying merits when it seeks a stay on a threshold issue. See, e.g., Gutierrez v. Seents, Office of Personnel Management v. American Federation of Government Employees. The government here is likely to suffer irreparable harm from the district court's entry of injunctions that likely exceed the authority conferred by the Judiciary Act. And the balance of equities does not counsel against awarding the government interim relief. A partial stay will cause no harm to respondents because they will remain protected by the preliminary injunctions to the extent necessary and appropriate to afford them complete relief. E. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power, too. The government's applications for partial stays of the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. Applications for partial stays granted. Barrett delivered the opinion of the court, in which Roberts, Thomas, Alito, Gorsuch, and Kavanaugh joined. Thomas filed a concurring opinion, in which Gorsuch joined. Alito filed a concurring opinion, in which Thomas joined. Kavanaugh filed a concurring opinion. Sotomayor filed a dissenting opinion, in which Kagan and Jackson joined. Jackson filed a dissenting opinion,